Please be seated. Court now calls case number CV140229, Taylor versus APS. This is the time set for oral argument. Good morning, counsel.
Good morning.
Keep in mind that these proceedings are audio and video recorded. They'll be posted to the court's website within a few days of today's argument. Please identify yourself and your client when you step up to the podium. Each side has 20 minutes. Counsel for the appellant, if you want to reserve some time for rebuttal, just let us know. We've read the briefs. We've discussed the case. We're very familiar with the issues in your case, so keep that in mind. Let's see. Mr. Countryman?
Yes, Your Honor.
Your argument?
Good morning, Your Honors. May it please the Court, Ken Countryman on behalf of Teron Taylor, who is the appellant in this matter, Judge. Your Honor, from our perspective, this case boils down to whether a utility company can use an accord of can avoid accord and satisfaction by arguing that its undisclosed understanding is different than the words and documents which comprise the written agreements. As this Court is well aware, the Teledyne case sets forth that the policy favoring settlements where there's a real genuine contest between the parties is a favored policy absent some sort of fraud, misrepresentation, when there's an undetermined amount at stake here. In this case,
isn't it that the plea agreement that you cite as the accord and satisfaction is for a shorter time with the state of Arizona than it was with APS?
Judge, when the case was initially filed, the allegation against Mr. Taylor was that he had essentially stolen services for approximately a decade. The case was filed, and the dates that were alleged covered that time period. Because there was a lot of litigation, a lot of motions, and when this case was civilly settled between the parties, there were 6 pending motions, and the court had indicated that they were not going to allow APS to use documentation or information that they failed to disclose. The problem from APS's perspective with this case, Your Honors, was they had monitored Mr. Taylor's services for approximately 6 months. But the other amounts were based on projections, neighborhood projections that they wouldn't provide to the defense in the criminal case. And so the state the city of Phoenix ended up amending the complaint to narrow it down to the monitored activity because of the litigation that ensued. But APS never, ever withdrew the amount of restitution that they were seeking, which was almost $30,000 during the course of that negotiations and terms. It was only until the fact that there were these pending motions to preclude, there was a search and seizure issue and other issues, that there was a civil settlement between the parties and the amount that's in the brief, Judge. So there was never an issue with regard to the amount of time until APS wouldn't disclose the information. And then in terms of the restitution, there was always a claim for the whole thing until they couldn't really show how much was owed. And so that amount, Judge, in our position is everything was covered. And in addition to that, Your Honor, I think it's key for the court to note the amount that was paid by Mr. Taylor to civilly settle this case was in excess of the monitoring that was done for that short time period. In other words, he paid more than he would have paid during that time period because APS interjected investigation costs that uncovered the entire investigation, and there was a dispute over the amount owed. So in essence, Your Honor, no. The issue of this was a shorter period of time never came up until APS decided we're going to sit back, we're going to resolve this criminal case because we've got issues with this. We know we've got, the state has suppression issues, the state has issues of proof of the amount in question, so we're going to resolve this for an amount, and then we're going to lay back and wait and immediately seek to turn off Mr. Taylor's power for the other issues, which, because of the strength and the position that Mr. Taylor was in, Your Honor, in the criminal case, the only reason he entered into that civil misdemeanor compromise case was because he wanted to resolve the dispute over the entire period of years.
He also wanted to avoid criminal prosecution, right?
Well,
Going to prison?
Well, this was a misdemeanor, so there was a jail. Yes, there was the state was initially offering 90 days in jail. So I would.
That wasn't a big consideration in the agreement?
Judge, knowing the case the way I did, I would have to concede it was a consideration, but I don't think it was a big consideration because of the posture of the case. There were 6 pending motions, and they had things had been precluded, and there was a recording where the police department had came on the property and without a warrant and done some issues. So I don't think Mr. Taylor was very concerned about the criminal prosecution, but obviously getting rid of a criminal case is something that is a factor that is a consideration. But again, that could have been done with the state. This is a misdemeanor compromise is a civil settlement between the parties. And so his main motivation and his main factor there in this case was resolving this issue about the monies owed. And this is why, from a policy perspective, Your Honors, APS should not be allowed to sit back and say, okay, you owe us all this money. We're going to refer this case for criminal prosecution to get our money. When we have these issues and we have these problems legally with disclosures and warrants and those things, okay, we're going to, in our minds, settle a small piece of that, and then we're going to turn your power off for the other part. When that was never made clear, the only time they tried to change it into a liquidated and unliquidated amount, 2 separate amounts, was after this was resolved through the misdemeanor compromise, which is a civil settlement, and then they sent a notice to turn the power off. In fact, Mr. Taylor, as the record shows, called APS and said, hey, what is this notice? And it's a mistake. So, you know, from a policy standpoint, this should not be allowed. And in addition, the statute is very clear. If it turns out that Mr. Taylor's thinking, hey, I got this monetary part resolved, and APS is thinking, okay, well, we're going to resolve the part where we monitored and we know that amount, but we're going to just lay back and unresolve the part that's unmonitored, that we have to give projections and guesses about how much is owed because we don't know and we don't want to disclose our neighborhood projections and those things. The statute covers that. In this case, it would have been very simple for APS to say, because they received a letter from Mr. Taylor's counsel saying, hey, we resolved this. And that was done about a month later. This is resolved. They acknowledge receipt of that letter. And that statute is very clear. If you have a dispute that the parties may have had a disagreement or misunderstanding about, you got to send the check back.
Is a party's recovery in a civil action limited to the amount of restitution received in a criminal action?
Absolutely not. Absolutely not. As a primarily criminal practitioner, the restitution can be conditioned on anything that's reasonably arises out of the facts. And so in this case, that's why APS continually asked for what they believe was full compensation until they ran into problems with disclosure and motions. And the state ran into problems with law enforcement going on somebody's property without a warrant. And so there are cases resolved every day where somebody's charged with 5 counts, 8 counts. They plead to 1 count, but they still have to pay everything that's related to what's restitution. And so when you see...
Would the Fourth Amendment issue preclude recovery in a civil case?
No, absolutely not. But that's why I'm trying to explain to court in the criminal case, the 6 motions that were pending that Mr. Taylor had put the case in serious jeopardy, and the court had already indicated they were going to preclude the things that APS, that the state wouldn't disclose, that were being requested, that APS didn't want to give up. And so, getting back to the statute, that's why the statute is very clear. The statute says, okay, in these situations, when, okay, the parties may misunderstand each other, APS is saying, okay, well, we'll resolve that part, but we're going to get our money, we're going to turn your power off. And Mr. Taylor's sitting there saying, I'm in control of the criminal case because of all the errors and the lack of disclosure that's going on, but I still have this dispute with the only person I can pay to have power. I'll give you a check so I can move on from this. And that's what happened in this case. Mr. Taylor sent them a letter explaining, hey, I resolved all of this. They acknowledged receipt of the letter. They never sent the money back. And Judge Brain, who I think erroneously said, well, you can't get the benefit of a criminal resolution and a civil settlement, I think that's an error. This could have been corrected very easily. The APS could have said, here's your check back. We're not compromising. Because a misdemeanor compromise is between Mr. Taylor and APS. It has nothing to do with the City of Phoenix. APS could have said, City of Phoenix, hey, we don't have a misdemeanor compromise. This was an error. Mr. Taylor would acknowledge that. Hey, this is an error. We don't have a misdemeanor compromise. I believe Mr. Taylor would have stipulated to the reinstatement of the criminal prosecution because of an error in the misdemeanor compromise. I don't believe that the City of Phoenix would have had to refile any charges. They could have just stipulated that there was an error. The court could have made a ruling and reinstated the prosecution and gone from there. But instead, it's actually APS who decided, hey, we're going to take this money for this. And by the way, it's very important to note, they were compensated for their entire investigation. That investigation covered the entire investigation that they'd done for the 10-year period, not just that 6 months. And so they got the check, and then they said, okay, we're turning your power off. And they got the letter from Mr. Taylor. They acknowledged receipt of the letter. They never sent the check back. And then Mr. Taylor, because of the threat of having his power turned off, had no recourse other than to seek a lawsuit to try to enforce what he believed was done in this case. And so that statute, which is very clear, says, and they can't get away from any exceptions, if you don't send the check back in the context of the civil litigation, then you're bound by the resolution. It actually allows for the situation where there may have been a legitimate disagreement here, because APS never told Mr. Taylor, look, we'll resolve this, but we're going to turn your power off for those other 8 years that we can't prove how much money you allegedly took, and we don't want to give you the documents. And so,
Let me ask this hypothetical.
Yes.
If the money had been returned, there had been a trial, and Mr. Taylor won, couldn't APS still sue him civilly?
well, yeah, because the state had to, again, they started with alleging the entire period. They amended the complaint. And so if that would have been fully litigated, yes, they could have said, we'll go back now and we'll sue you, or we'll turn your power off, or we'll do whatever because of the amended complaint, which goes back to my point of why Mr. Taylor was wanting to resolve the whole thing. He had a good faith belief, okay, I don't want to deal with not having power. I don't want to deal with litigation over something. I don't believe APS would have sued because they never wanted to give up the documents concerning their neighborhood projections as to how much power or services was taken. They didn't want to do that, which is why they were in a box on the criminal case. So, yes, they could have sued, but that's because that period would have been fully litigated and the complaint to cover the whole time period was amended. So, again, that's why Mr. Taylor said, I want to resolve this. I want to move on from this. And then immediately APS turns around and says, okay, yeah, it's resolved, but only for the amount we can prove because we monitored. That other stuff that you thought you settled, no, we're turning your power off. And that's from a policy standpoint we're trying to avoid. Look, I understand sitting here, Mr. Taylor's not a model plaintiff in this situation. He's been accused of taking power, and I understand Judge Brain probably had an issue with that. But that's really not the issue here. The issue here is he allowed to try to resolve this dispute that he had when he's simply saying, tell me how much I owe you. If you claim I owe you this money, tell me how much. And APS says, we don't want to tell you. We're not giving you our projections. We're not telling you anything other than what we monitor. And at some point, his counsel says, look, it's better off you resolve this. He resolves it. He thinks he has it resolved. And they turn around and say, no, you didn't. And we're not going to show you our projections. And that's the thing. The way they did this, they did it in a way where they didn't have to give them the projections because they just sent them a notice, we're going to turn your power off. There's no litigation in that. That's not fair when you resolve something in a misdemeanor compromise, which is between the Mr. Taylor and APS. It has nothing to do with what the state's doing. And in fact, I think that's really where Judge Brain got it wrong, is that whole interaction with the state That's just a form the state filed, and Mr. Taylor doesn't even sign the form that's turned in. The compromise is the letter from Mr. Taylor, the email back from APS, and the actual check that was delivered. And if there's a legitimate dispute, if APS is saying, well, we only settled this because, we could have proved that 6 month period, that wasn't in Mr. Taylor's mind, and that's why they should have sent the check back. They should have sent the check back. They can't just sit there, and Mr. Taylor didn't sit back and go, well, that's settled, I'm just going to ignore you. He sent them a letter saying, hey, this is resolved. They had time to send the check back. They had time to tell the city of Phoenix, hey, we don't have a compromise. Mr. Taylor's counsel absolutely would have stipulated to a reinstatement of prosecution based on the both parties not understanding what was going on. And that's what they did in this case, and it's certainly not appropriate. Your Honor, it looks like I have about 4.5 minutes, so unless there are any questions now, I want to reserve my time.
Thank you, counsel.
Thank you, Your Honor.
Mr. Gaona?
Sorry, counsel, let me just...
May it please the court, David Gaona for the Appalachee Arizona Public Service Company, or APS. First and foremost, thank you for your time this late morning. Irrespective of what has been articulated to your honors thus far, this is a really easy case. It's neither complex nor problematic. First of all, everything that was said to your honors about APS and sort of controlling the strings of the criminal prosecution, if you will, or that was certainly the difference, I can't speak to. APS was a victim in the underlying proceedings. It wasn't the prosecutor. It wasn't advising the prosecutor about what to do. APS, as it relates to the underlying record, obtained an affidavit from the prosecutor who was involved in prosecuting that misdemeanor theft of electricity matter, Christian Bell. And Mr. Bell, in his affidavit, which is uncontroverted in the record, said, number one, the complaint I filed initially put the date of the incident as June 29th, 2011, which was the end of the 5-month period. And then he said, after a while, I amended the complaint, which was uncontroverted, to make sure everyone understood that the only thing I was prosecuting was a 5-month period of time, February 1, 2011 through June 29, 2011. So he makes it clear about what was going on in the underlying criminal proceeding. Whether there were problems in terms of discovery disputes between the defendant and the state, I can't speak to. APS was not a party. APS wasn't requested to provide documentation. We weren't a party. So I can't speak to any of that stuff, and I'm not going to. I'm not going to speculate, because that's all I've heard thus far, is speculation about what would have been done, what should have been done, what could have been done. I'm here to talk about the facts presented before Judge Brain.
What about the assertion that this was eventually a misdemeanor compromise and that APS became a party to that because the charges are being dismissed?
I think that's somewhat accurate, and I pulled ARS 13-3981 on misdemeanor compromises. And first and foremost, the underlying offense has to meet 3981A. And this one does. The theft of electricity can be remedied by the victim by filing a civil action. We don't dispute that. And then after that, the injured party has to go to court and appear before the court in which the action is pending before trial and acknowledge, quote, that he has received satisfaction for the injury. In fact, that is what occurred. APS was contacted, and it's undisputed in the record, by Mr. Bell and an APS representative, Mr. Rose, that Mr. Rose got a call from Mr. Bell saying, we want to resolve the dispute. Would you agree to a misdemeanor compromise? The 5 months of diverted electricity and any other additional expenses, what is that total? Is $4,300 cover it? $4,300 covers it. Will you agree to this? And they said yes. And so part of the agreement was the $4,300 covered the 5 months of diverted electricity plus costs associated with putting the sub-meter in the ground for that 5-month period of time, as well as executing a misdemeanor compromise document, which was undisputed in the record as well. And that misdemeanor compromise document, signed by the prosecutor, signed by APS, and approved by the court, says as follows, words to the effect, this makes APS whole for any injury relative to the time frame between February 1 and June 29, 2011. APS wasn't trying to pull the wool over anyone's head on this case. APS was just doing what it was asked to do by the prosecutor, who said, it's only for this time frame. You keep all your rights as it relates to pursuing Mr. Taylor, if you wish, for any other time frame. That's undisputed.
So you acknowledge that to the extent of the agreement, APS is bound by that number for whatever the agreement was.
Absolutely. And APS is not seeking, nor has it ever sought, any further monies relating to that 5-month period of time that it gave up by accepting the $4,300.
You're also not saying, well, whatever the prosecutor did in that agreement, we're not complicit with. You were involved in that.
All we can say, and it's said in the record before your honors, is we got involved in that process because here's what the prosecutor told us it meant, and here's what the prosecutor told us we were giving up, which was 5 months that he was prosecuting for purposes of the resolution. As it relates to Judge Brain's determination, Judge Brain dismissed their motion for summary judgment because they failed to file a Rule 56C3 statement of facts appropriately. It's that simple. Judge Brain accepted our motion for summary judgment that there was no accord and satisfaction based on what I just told your honors. All Judge Brain had was affidavit from Christian Bell, affidavit from Mr. Rose from APS, the misdemeanor compromise, and acceptance of a check that said settlement of all claims with APS per agreement with the state. APS got that, said, yeah, Mr. Bell, the prosecutor, told us here's what it means, we'll accept that. Judge Brain made it very clear that's enough. But if that weren't enough, then APS accepted something based on the representations of the state, and therefore there could still be no accord and satisfaction in the circumstances. There was no mention by Mr. Countryman as it relates to any issues relating to the second motion for partial summary judgment that Judge Brain granted, which concerns the termination of electric services. Because he hasn't argued that, I'm not going to touch it. I'll rest on the briefs. I believe that was stated appropriately as well. And subject to any questions that the court may have of me, we appreciate your time and patience this morning.
I was going to say, other than the 5 months, to the extent that it would have or could have or should have been for a longer, could the parties have negotiated that through the state?
Your Honor, at all times, APS was aware of the fact that it was for a 5-month period of time, and that's all it was interested in dealing with at that time. Could they have? I guess they could have. At any time, APS could pick up the phone, or Mr. Taylor could pick up the phone and say, let's resolve this other thing. Didn't happen.
Thank you, counsel.
Thank you, Your Honors.
Mr. Countryman?
Thank you. I will just address 2 points concerning what was raised by counsel. First of all, with regard to the striking the statement of facts, first and foremost, there really isn't a dispute about the facts in this case. In fact, prior, when we told Judge Brain we were going to file a motion for summary judgment, counsel said he'd stipulate to the facts because the facts are essentially undisputed. We did file the facts, and we don't rest on the pleadings as to why Judge Brain was erroneous in striking our statement of facts. But the facts were included, the facts were attached, and the facts were set forth. And there's really no dispute about the facts in this case. We do take issue with APS saying they never sought more money than was requested from that approximately 6-month period. They asked for initially $20-something thousand in restitution as part of the resolution of this case. There's no way that they could say that didn't cover that other period. They also just acknowledged that they recovered investigative costs that covered the entire period. The investigation started prior to them putting on this monitoring device. So why did they receive restitution for that when that doesn't arise out of the case? They did an investigation. They said, okay, we're going to put in a monitoring device. They put in the monitoring device, and then they're asking for monies over a 5-month period that doesn't anywhere come close to $4,300. And so they're simply wrong about that. And again, if If there was a dispute, legitimate dispute, why didn't they send the check back and have the prosecution reinstated? They never did that. That's what the statute commands. We wouldn't be here. We wouldn't have to file briefs and expend monies if APS had simply followed the statute that said, okay, we've got 90 days to send this money back, and we'll make a phone call to the prosecutor or an email. It wouldn't even have taken anything significant, an email saying we actually don't have a resolution, we need to reinstate the prosecution. They would have called Mr. Taylor's counsel, and then we would have went forward. And so, again, they're completely wrong about that. And there's nothing in the record other than they got an affidavit from Mr. Bell regarding what Mr. Taylor's understanding was with the state, and that lies the problem. The misdemeanor compromise is between Mr. Taylor and APS. Any communications that they had with the state, which they just mentioned that the state told them this, that the state told them that, those conversations never happened with Mr. Taylor. Those were never communicated to Mr. Taylor's counsel. And so Mr. Taylor, as he sits here and tries to say, okay, I'm in control of the criminal prosecution, but I still have to have power for my wife and my kids, it's better to resolve this. He resolves it, and then they turn around and say, no, actually, you haven't resolved it. And so that's why the statute is written the way it is. That's why the case law is very clear the way it should be done. And you know, it's just, you can't enter an agreement with Mr. Taylor that says, hey, we're going to take more money than this 5 months covers and say it's not a resolution of all claims when it says resolution of all claims, and then turn the power off because the state told him something that Mr. Taylor wasn't a party to. That's flat out wrong. And the policy is very important here. Again, whether Mr. Taylor stole services or didn't steal services, that was a subject of dispute about how much. The case was dismissed. This case was civilly settled between APS and Mr. Taylor. Mr. Taylor communicated immediately, hey, this is not my understanding of what happened. The APS acknowledged in a letter, yeah, we got that, but too bad. Too bad, we got your check, we're keeping your check, and we'll see you go get a generator or go get something to keep power on in your house. Your Honors, clearly there was an accord and satisfaction in this case. Clearly, under the statute, APS had a responsibility to either return that check or they're stuck with it. And that's what we're here for.
Thank you, counsel. We'll issue a written decision in due course. Court's in recess.